Good evening to the aspirants of the AP+TS JCJ 2023. You are welcome to my virtual class. And in my last class, that is on Saturday, I dealt up to the 25th questions. Now I will start from the 26th question. Be ready to shoot. 26th question. Revenue matters, rent matters, family matters, military matters, special tribunals, unless they are expressly or impliedly barred or dealt by the virtue of dash of the CPC 1908. Option A, Section 7, Option B, Section 8, Option C, Section 9, Option D, Section 10. Shoot.
Section 8, sir.
WRONG. Second option.
Section 9, sir.
Section 9 is the right answer for the 26th question. Section 9 says, revenue matters, rent matters, family matters, military matters, special tribunals, unless they are expressly or impliedly barred and dealt by the virtue of the Section 9 of the CPC 1908. Now the 27th question. Anyone can unmute and read the 27th question? Anyone can unmute and read the 27th question?
It is applicable to all civil courts, including Supreme Courts, in all suits as well appeals. Appeal lies under dash CPC.
Options.
Option A, Section 10. Option B, Section 11. Option C, Section 12. And Option D, Section 13.
The question is, it is applicable to all the civil courts, including the Supreme Court, in all suits as well as appeals. Appeal lies under dash of the CPC of 1908. A, B, C, D. Shoot.
Section 11, sir. D.
Section 11 is the right answer for this question. For 27th question, Section 11 is the right answer. Now 28th question, Section 12, subsection 2 of the CPC is applicable to, within parentheses, which is the odd man out, means not relevant. A, writ jurisdiction. B, negotiation proceedings. C, arbitration proceedings. D, banking.
Option A, sir. Writ jurisdiction.
Writ jurisdiction is there. WRONG. Next option. Shoot, even though it is wrong, no negative marks.
Option B, sir. Negotiation.
Negotiation proceedings are not there, but arbitration proceedings are there. I fabricated negotiation proceedings, which is odd man out, not applicable to it. But the rest of the other three, that is the writ jurisdiction, C, arbitration proceedings, D, banking. Now 29th question. Section 12, subsection 2 of the CPC is applicable to, which is not connected to this section, means odd man out. A, matters. B, things. C, rent restriction law. D, execution proceedings. Shoot. One I fabricated, other three are relevant.
Option B, sir. Things.
B, I fabricated. There no things are there. Matters, yes, connected. Rent restriction law connected. Execution proceedings connected with the section 12, subsection 2 of the CPC. Now, 38th question. According to Dash of Limitation Act 1908, for filing an application against such order, etc., within the 3 years. Option A, Article 95. Option B, Section 95. Option C, Section 96. Option D, Article 96. One thing is very much clear here. We don't say Constitution sections. We don't say Constitution articles. In the same manner, we don't say sections in the Limitation Act, but we do say articles. Now, I made it very much clear to you.
Option D, sir. 96.
WRONG. It is
Option
Article
A,
95. According to Article 95 of the Limitation Act 1998, for filing an application against such order, etc., within 3 years limitation period. Yes, 31st question. Match the following terms from Part A and explanations on Part B. Here, Part A, 1. Appeal. 2. CPC review. 3. Revision before High Court. 4. Innovation of the inherent powers of the High Court. Under the Part B, I have given the Section A under Section 115, B under Section 151 CPC, C under Section 114 of the CPC, read with the Order 47, and D under Section 96. Now the match the following. And here I matched it. A, 1C, 2A, 3D, 4B. B, 1B, 2C, 3A, 4D. C, 1D, 2C, 3A, 4B. D, 1B, 2C, 3D, 4A. And here the match the following. And here the options.
Option C, sir. C.
Yes,
1D,
you're right.
2C.
Option C is the right answer. That is 1D, 2C, 3A, 4B. Here if you see feedback, appeals under Section 96. CPC review under Section 114 of the CPC, read with Order 47. Revision before the High Court under Section 115. Invocation of the inherent powers of the High Court under Section 151 CPC. Hence, C is the right answer. That is 1D, 2C, 3A, 4B. Now, next question, 32nd question. Foreign judgment is not conclusive if, which is a correct statement. 1. Where it has not been pronounced by a court of the competent jurisdiction. 2. Where it has not been given on the merits of the case. 3. Where it has not been obtained by fraud. 4. Where proceedings in which a judgment was obtained are opposed to the natural justice. And the options we are given here is A, 1 plus 2 plus 3, B, 2 plus 3 plus 4, C, 1 plus 2 plus 4, D, 1 plus 3 plus 4. I said correct statement. I made one mistake there, and among the 1, 2, 3, 4, and what is that mistake? And I made the options here. Foreign judgment is not a conclusive if I have given where it has been pronounced by a court of competent jurisdiction. Not been pronounced by a. That means if it is pronounced by the competent jurisdiction, then it is a conclusive. That's why not is given over there. Should. Participants, are you hearing me?
Option A, sir. 1, 2, 3.
WRONG. Option C is the right answer. In 3, I committed a mistake where it has not been obtained by fraud. No, it has been obtained by fraud. I put the not there. But actually, where it has been obtained by fraud, at that instant, it is not a conclusive judgment. But I wrote where it has not been obtained by fraud, because to confuse you, all the nots are there. Here not is there, here not is there, and here not, I put it there because it is correct. Where proceedings in which the judgment was obtained are opposed to the natural justice. Opposed to the natural justice, yes, it is not a conclusive proof. So the right answer is 1 plus 2 plus 4. That is the correct statement. The wrong one is where it has not been obtained, but actually it is where it has been obtained by fraud. So that is the feedback. Is it clear?
Yes, sir.
Okay, now 33 question. Match the following part A, orders, and the explanation part B. In the part A, there is a orders are there, and part B, explanations are there. So let me read 1. Order 39 rule 6. 2. Order 40 rule 1. 3. Order 40 rule 2. 4. Order 40 rule 3. When you come to the ABCD, A, how a receiver is appointed. B, what are the interlocutory orders. And 3. C, duties of the receivers. D, powers of the receivers. Now here made the options. A, 1C, 2B, 3D, 4A. B, 1B, 2D, 3C, 4A. C, 1B, 2A, 3D, 4C. D, 1D, 2C, 3B, 4A. And here the match the following. And here options. Now shoot. Yes. Unmute and speak.
Sir, can you scroll down? Unable to see the question.
Yes. That is the question. And here are the options. Can I drag it down so that you could see the both of them? Yes, now you could see the both of them. Shoot now. Even though it is wrong, no matter.
Option C, sir.
Option C is the right answer. 1B, 2A, 3D, 4C is the right answer. See the feedback. Order 39, Rule 6. What are interlocutory orders? Order 40, Rule 1. How a receiver is appointed. Order 40, Rule 2. Powers of the receiver. Order 40, Rule 3. Duties of the receivers. Is it clear?
Yes, sir.
Yes. Okay. 34th question. Orders 39, Rule 2. What are the remedies against the breach or the violation of an injunction? Which one is the correct option among the 1, 2, 3, 4 here I have given? Number 1, contempt of court. 2, attachment of the property for a period not more than 1 year as a whole. 3, if disobedience or a breach continued, the property attached may be sold. 4, imprisonment for a term exceeding the 6 months unless in the meantime the court directs his release. Options are given. A, 1 plus 2 plus 3. B, 1 plus 3 plus 4. C, 2 plus 3 plus 4. D, 1 plus 2 plus 4. I made some wrong in 1, 2, 3, 4. 1 I made wrong.
Option C, sir. 2, 3, 4.
WRONG. Next option. Srinivasa. What are
Option D, sir. 1, 2, 4.
WRONG. The answer is A. 1 plus 2 plus
A.
3 is the correct answer because 4 I committed a mistake there. Imprisonment for a term exceeding 6 months unless in the meantime the court directs his release. What I did know, I removed the not from imprisonment for a term not exceeding actually. Not exceeding 6 months. But I removed the not here from here. I removed the not. And actually imprisonment for a term not exceeding the 6 months unless in the meantime the court directs his release. So 4 should be eliminated. So in the all the 4s are there here. B 4 is there, C 4 is there, D 4 is there, but A no 4 is there. That means the correct option is
A.
A 1 plus 2 plus 3. Okay, 35th question. Ingredients for grant of temporary injunction. Which is the correct option? Repeat. Ingredients for grant of temporary injunction. Which is the correct option? Here I have given. Number 1, pending suit. Number 2, balance of inconveniences. Number 3, irreparable damage or injury. Number 4, prima facie case. So now A 1 plus 2 plus 3, B 1 plus 3 plus 4, C 2 plus 3 plus 4, D 1 plus 2 plus 4. Among the 1, 2, 3, 4, 1 I made a wrong statement.
Option D, sir. 1 to 4.
WRONG.
2, 3, 4, sir. Option C.
Are you sure?
Yes, and in 2, sir, balance of inconvenience you wrote, but it is what I read is balance of convenience.
And
And pending suit, I don't know. So 2, 3, 4.
yes, actually it is not balance of inconvenience, that is. So right answer is
2, 3, 4. Option C.
yes, option C is the right answer here. Yes, you are right. Because I committed a mistake, but option C is the right answer here. Okay, anyway, that good. Right, now next question. When an attachment is withdrawn, which option is right? I repeat, 36th question. When an attachment is withdrawn, which option is right? Number 1, attachment before the judgment can also be withdrawn when the defendant furnishes the security required together with the cost of the attachment or when the suit is dismissed. 2. When the attachment before judgment is made, it shall not be necessary for the plaintiff to apply for the reattachment in the execution of a decree. 3. Agricultural product is exempted from the attachment before judgment. Small causes code don't attach the immovable property. And here I made the options. A 1 plus 2, B 2 plus 3, C 1 plus 3, D 1 plus 2 plus 3. Which option is right?
Option A, sir. 1, 2.
Why 1 plus 2 only right? Is not the 3 is not right? Agricultural production or products is exempted from the attachment before the judgment. Small causes code don't attach the immobile property. It is also right statement. Number 1 also right statement. Number 2 also right statement. Then
1,
which
2,
option is
3.
right?
D.
D is right. 1 plus 2 plus 3 means all options are right. Is it clear?
Okay, sir.
Now 37th question. Anyone can unmute and read 37th question. Unmute and read. 37th question. Participants.
What is the order for summary suit in CPC? Option A, order 35. Option B, order 36. Option C, order 37. Option D, Order 38.
Summary suits.
Option C, sir,
Option
37.
C is the right answer. Order 37 is deals about the summary suit in CPC 1908. So 37th question, right answer is C, Order 37. Now let us see the 38th question. What is garnishi order? Which order and rule says under the CPC 1908? Option A, Order 21, Rule 46. B, Order 46, Rule 21. C, Order 22, Rule 46. D, Order 46, Rule 22.
Option A, sir, 21,
Option A
46.
is the
Option
right
A, Order
answer.
21 rule.
It is Order 21 and Rule 46 says about the garnishi. Supplementary question. What is meant by garnishi? Even that can also be asked. Anyone? What is meant by garnishi? You read in the contract this thing. Yes? You don't know what is meant by garnishi? I will show you here so that you should not forget it. Garnishi. Okay, even though I committed a mistake, doesn't matter. It will calculate it. It will make it right. Garnishi means, read. Read, what is meant by garnishi?
A third party who is instructed by way of legal notice to surrender money to settle a debt or claim
Is a garnishi order, that is called. The
yes.
third party who is instructed by way of legal notice to surrender the money to settle and debt a claim. What is the meaning of the word garnishi? And here also given, a company, a person, etc., who is ordered by the court to garnish part of someone's income or property in order to pay the debt. So they give the company a notice, they give the person a notice who is a third person to pay it by the court to the garnishee. It means like a security man, surety man, part of someone's income or property in order to pay the debts. He should have to pay the debts. Who? Third party. And that's why we can say it's a garnishee. And who take the responsibility to pay it. Like a surety, in other words. Am I right?
Yes, sir. Yes, sir.
See, if the original debtor will not pay, the court will order the surety to the pay, or his income will be attached. Is it clear?
Yes, sir.
Don't become a surety unless until that you know him, he will not be a defaulter. Otherwise, defaulter will be left over and the person who is a third person and his salary will be attached to pay the installment. So 39th question. Which one is the correct option for the content of the plaint? Not plant, plaint, that is not plant. Okay. Number 1, name of the parties. Number 2, name and description of the place of residence of the plaintiff. 3, name and description and the place of residence of the defendant. And 4, where the plaintiff or defendant is a minor or unsound mind, a statement to that effect. So here I have given the options. A, 1 plus 2 plus 3. B, 1 plus 3 plus 4. C, 2 plus 3 plus 4. D, 1 plus 2 plus 3 plus 4. Which one is the right answer?
Option D. Option D. 1 plus 2 plus 3 plus 4.
Are you sure?
Yes, sir.
Option C.
No, I committed some mistake there in one. In one, I have committed a mistake. I mean, I intentionally made it. It is not the name of the parties. It is the name of the court. Now you tell me.
Option C, sir. 2, 3, 4.
C is the right answer. You eliminate one because it is not the name of the parties. It is the name of the court. Is it clear?
Yes, sir.
Okay, now the 40th question. Which one is the correct option for the content of the plaint? Now, and here you can read number 1, facts constituting the cause of action and when it arose. 2, the facts show court jurisdiction. 3, the relief claimed by the plaintiff. 4, where the plaintiff has not allowed to set off or relinquished a portion of his claim, the amount so allowed or relinquished. So for 1, 2, 3, 4, I committed some fabricated, at least one there. Here the option is. Please mute. Somebody. I don't know.
A is right answer, sir.
Srinivasa, Otari Kari, please mute it. Yes, thank you very much. Because I got the resound from you. Okay, now in 1, 2, 3, 4, I made a fabricated one wrong. And here I have given the option A, 1 plus 2 plus 3, B, 2 plus 3 plus 4, C, 1 plus 3 plus 4, D, 1 plus 2 plus 4. Shoot, which is the correct option?
Sir, A is right answer, 1 plus 2 plus 3.
You are right. Yes, now mute it immediately because when you speak, I am getting the right sound. Okay, now next question is, yes, where the plaintiff has allowed, I said, because he has not allowed. Here I put the intentionally not. Actually, plaintiff has allowed means fourth I made the wrong statement and hence that option is the right answer, eliminating the fourth one. So for the first question, match the following keywords from part A and the section of the code from part B. Part A, I given all the number 1, orders, number 2, decree, number 3, judgment, number 4, recognized agent and pleaders. In part B, A, defined under the section 2, subsection 2, or the B, defined under the section 2, 14, C, order 3 of the code 1908, and D, defined under the section 2, 9. Now option I have given here, A, 1C, 2A, 3D, 4B, B, 1B, 2A, 3D, 4C, C, 1A, 2D, 3C, 4B, D, 1A, 2C, 3D, 4B. Shoot.
Sir, A, 1C, 2A, 3D, 4B, sir.
WRONG.
Sir, option B.
Option B is the right. Option B is the right. Now I here show the feedback. Order defined under the section 214. Decree defined under the section 2.2. Judgment defined under the section 2.9. Recognized agent and pleader, order 3 of the code of 1998. So the right answer for the above question is B. 1B, 2A, 3D, 4C. Okay. Now let us go to the 42nd question. The case of dash that is decided in the 2020 is an appeal case brought before the Supreme Court of India to challenge the judgment. To challenge the judgment delivered by the Gujarat High Court that declared a suit filed by the appellate to be barred by the deputation under the Rule 911D, Order 7 of the Code of Civil Procedure 1998. What is the name of the case law? A. Khatri Hotels Private Limited and other versus Union of India and another. B. Dahi Behan versus Arvind Bhai, Kalyanji, Bhanusali. C. Madamuri Sri Rama Chandra Murthy versus Syed Jalal. D. Sher Singh Yadav versus Harsh Kapoor and others. These are the 4 cases.
Option B, sir. Dahiben versus Arvind Bhai Kalyanji Bhamnusali.
You are right. I appreciate. Can I tell me that what the method that you are adapted to find the answer?
Sir, I am already your student for AIB 17, so I know.
So you know the technique of shooting.
Sir, can I tell the technique, sir?
Yes, sir.
Sir, it is in Gujarat, Bhai would be
yes.
all names.
I appreciate. Just use the logic.
Yes, sir.
Enough. You can use the logic. You can easily make it out. But I trained you how to use the logic. And I told you several times how you can make it out. Even though you don't know the answer, but you can shoot the right answer. Even though you don't know the answer. Because I trained you in x-axis, y-axis, d-axis in 3-dimensional. At least you can use one trick, second trick, third trick, and you can know what is the right answer, even though you don't know the answer. Okay, now let us go to the next question. The Calcutta High Court, while deciding the case of Dash, it is decided in the 2021, laid down a proper distinction between the temporary injunction and Order 39 Rule 1 and order for the attachment before the judgment under the Order 38 Rule 5 of the Civil Procedure Code 1998. Here are the cases. A. Raman Tech and Process Engineering Company versus Solanki Traders. B. Bhoop Singh versus Union of India. C. Prabha Surana versus Jaideep Halvesia. And D. Anita Agrawal versus State of HP, Himachal Pradesh. Now shoot.
Sir, I think A is the right answer. Raman Tech versus Process Engineering Company versus Solanki Traders, sir.
WRONG. Second option. Second option.
Option C, sir.
Option C is the right answer. Prabha Surana versus Jaideep Halvasia is the right answer for the above statement which is decided there. Now, 44th question. The Bombay High Court, while deciding on the case of Arvind Jairam Kotecha versus Prabhudas Damodar Kotecha 2020, took into consideration dash of the Code of Civil Procedure 1908, which provides a ground when a foreign judgment is not conclusive. Which section? Section 11, option B, section 12, option C, section 13, option D, section 14.
Sir, option C is 13, section 13.
Option C is the right answer. They took the defense of the section 13 and they say it's not a conclusive proof. I already told you in the foreign judgment which is not a conclusive proof. Number one, if it is not delivered by the competent court. Number two, if the court doesn't have the jurisdiction. Number three, if it is decided by the fraud. Number four, if it is against the nature of justice. And another point also there, if it is contrary to the constitution or the existing laws of the country where it is implemented or including the policy. At that instance, foreign judgment is not a conclusive proof. Is it clear?
Yes, sir.
I think you read this in the private international law. Recognition and enforcement of the foreign judgment. I wrote a beautiful article on this aspect, recognition and enforcement of the foreign judgment. I don't know whether you type it, whether you could find in the Google search engine. Okay, now 45th question. The practical application of the Code of Civil Procedure 1908 by the courts of India. All the judgment discussed uphold the underlying principle of the Code of 1998, which is dash, which signifies that where there is a right, there is always a remedy to safeguard the right when infringed. It's a taught maxim. I am sure that you can shoot it without any difficulty. A. UB just EB remedium. B. EB remedium EB just. C. Res ipsa laquitur. D. Novus actus intervenens. If you studied the law of
Answer B. EB remedius EB just, sir. B.
Wrong.
Option A, sir. A. Ubi just
Option A
remedium.
is the right answer. UB just EB remedium. Supplementary question. If the law of tort is not there in this, if the law of tort is there, they will ask, what is the trio maxims? Number one, demnem sine injuria. Number two, injuria sine demnem. Number three, UB just EB remedium. These are called trio maxims in the law of tort. Of course, we don't have the law of tort. Am I right?
UB just EB remedium.
Yeah, UB just CB remedium. Where there is a right, there should be always a remedy. Where there is a well, always there is a way. Am I right?
Okay, sir.
So now I bring down right. For 46th question. A suit filed on behalf of a minor. Of course, I copied it from somewhere because even I myself also don't know this one. A suit filed on behalf of a minor, A, cannot be withdrawn. B, can be withdrawn as a matter of right. C, can be withdrawn only with the leave of the court. D, none of the above. Yeah, you are right.
Can be withdrawn by the only leave of the court, sir.
Yes.
C is the right answer.
It is easy question, but anyway, if you see it, because if you see in the law of contract, you can sue a minor even though he is not competent to contract. On which occasions? In which occasions? When you supply the minor essential things to him, like roti kapda makan, essential things to him, even though he is not party to the contract, or even though he is not competent to contract, but theory of equity will come, you have to pay, even though he is not a party to the contract, because you supplied those things which are essential to him. But another famous case law is there. I don't know whether you remember the case law or not. Iman versus Fash. No, something. Let me remind you what is the case law. They supplied the three-piece suit to that Cambridge University student and whose age is 21 years. But he is already having the many suits, three-piece suits. And the three-piece suits is extravagant. It is not a basic necessity. I don't know whether you know it. Inam versus Marsh case law. Do you know what is meant by three-piece suit? Give me the answer.
Don't know, sir.
Three-piece suit means number 1, coat. Number 2, waistcoat, which is inside. Number 3, trouser or pant. I repeat. Number 1, trouser or pant. Number 2, coat. When you are wearing the coat, inside another small coat is there. Do you know that is called waistcoat? W-A-I-S-T, waistcoat. Are you following me?
Yes, sir.
Okay, sir. Okay,
That is
sir.
called the three-piece suit. I will show you the answer if the time is left. Okay, 47th question. A suit filed on behalf of a minor. A. I think we read it. Yes, we read it. 48th question.
repeated.
In which case? Dash. Section 22 of the CPC was construed. It has laid down that in an application for the transfer under the Section 22 of the CPC, the convenience of the parties alone should not be considered, but the totality of the circumstances should indicate that a suit should proceed in a court different from the court chosen by the plaintiff. Also, the mere convenience of the party is not enough for the transfer of a case from one court to another. So, which is the case law? A. Saurindra Narayana Bhanja Dio versus Ravindra Narayana Bhanja Dio. B. Josna Radia versus Jagpal Singh. C. MST Basanti Devi versus MST Sahodra. D. Manjari Sen versus Nirupam Sen. These are the 4 cases are there. And which case law it is decided about? The section 22 of the CPC, which construed.
Option C, sir.
You are right. It is MST Basanti Devi versus MST Sahodra. Now let us see 49th question. Which statement is the correct or exact statement? I repeat, which statement is the correct or exact statement? A. According to section 20 of the Civil Procedure Code, it is mandatory to mention the time and give notice of the application. B. According to section 21 of the Civil Procedure Code, it is mandatory to mention the time and give notice of the application. C. According to section 22 of the Civil Procedure Code, it is mandatory to mention the time and give notice to the application. And D. According to section 23 of the Civil Procedure Code, it is mandatory to mention the time and give notice of the application. So here A, B and C and D. What is the difference? Difference is section 20, section 21, section 22, section 23. And where mandatory to mention the time and give notice of the application. In which section of the CPC? Is it 20 or 21 or 22 or 23?
Sir, A is the right answer, I think, sir.
No, WRONG.
Option C, sir.
D for Delhi.
C for cat.
C for cat is the right answer. According to section 22 of the Civil Procedure Code, it is mandatory to mention the time and give notice of the application. C is the right answer for the 49th question. Now 50th question. In dash, the learned single judge of Punjab and Haryana High Court held that the High Court could examine the powers of transfer under section 23, subsection 3 to meet the ends of the justice and to prevent abuse of the process of the court. And which case law it is decided? A. Dalbir Singh versus Sakwa Industrial Private Limited. B. Ved Prakash Garg versus Seema. C. State Bank of India versus Sakova Industry Faridabad. D. State Bank of India versus Mr. Sakova Industry. Oh, I repeated this one. Now it is only 3 choices are there. Now you can easily shoot. See, only 3 choices are there. I repeated.
Sir, B, I think, sir. Ved Prakash Garg.
No.
Option C, sir.
Either you say C or D, doesn't matter.
Yeah.
State Bank of India versus Mr. Sakova Industry Faridabad Private Limited. It is decided that the learned single judge of Punjab and Haryana Court held that the High Court could examine the powers of the transfer under section 23(3), subsection 3 to meet the ends of the justice and to prevent the abuse of the process of the court. That is decided in that case law. Now 51st question. In dash, a division bench of the court held that no appeal will lie against the order of the single judge in appointing a receiver, but that order was passed in an appeal using the appellate jurisdiction. Here are the options. A. V. Gopinath Panikar versus Padmini Kunjamma. B. Osef versus Paili. C. Paminder Gujral and others versus Kiranjit Gujral and others. D. Against the order of the judgment in versus unknown. Shoot, which is the right answer for the 51st question and where it is decided among the A, B, C, D.
Option C, sir.
Option C is the right answer. No, wrong. Second
Option A, sir.
WRONG. The right answer is
Sir,
B.
B.
Osef versus Paili. A division bench of this court held no appeal will lie against the order of the single judge in appointing a receiver, but that order was passed in appeal using the appellate jurisdiction. So 52nd question. It was held that the Court of Rent Control is not a court under this, as it is not a subordinate to the district court or high court. Which section says? A. Section 24.2, B. Section 24.3, C. Section 24.4, D. Section 24.5.
Sir, B, section 24, class 3.
I don't think that's the right answer. Let me check it, because even myself also doubt. To my answer is section 24.5. That is what I feel. Now let us check it. Is it the correct answer for that one? Where it is mentioned. Section paste CPC 1908. CPC 1908, it is given still is buffering. He has given the so many cases. No, we don't need that one. We need this one. Let me see it. Again, it is given many cases. Let us see this one. Where any suit or proceedings has been transferred, withdrawn under subsection 1, the court which is there to dispose of such a suit proceeding may subject to the any special direction draft from there. It is not. We need actually the 24.5. So now let us check the CPC original case law. CPC, where I think I downloaded it. CPC Bear Act. Because when I read it, section 24, subsection 5, it said. But let me see the Bear Act, then we can know it. Bear Act of CPC 1908. Yes, this is the Bear Act, but we want the PDF. Is it the PDF? No, it is not the PDF. Yes, this is the PDF form. Right. So now, section 24, subsection, we want it. Is it not? In 24, say the general power of the transfer and withdrawal. They said, but whether 3, 4, 5 is there or not, I doubtful. So how do you make it out? Instead of saying Control F, if you make it out, then directly we can go to the 24, even class 1, let us see, so that we can make it out easily. It is not showing. Okay, let's make 24 section, 24, 2, 4. Yeah, this is shown here, 1. Then we can directly go 24, 24. No, this is not the point. Yeah, here it is given. Yeah. See, 24, general power of the transfer and withdrawal. Now we want 3 or 4 or 5. Power of the Supreme Court to transfer the suits on the application of the party and other notices and the expedient justice, high court and civil. Every application where it is made, 24, and this is the 2, this is the 3, this is the 4. This a suit of proceeding may be transferred under section from a court within has no jurisdiction to any trial. 25, then it came 25. I think let us make a subject to the correction. This one is, which one is? Let me try in another way. so that we could know which is the right answer for this question. Participants, are you there?
Yes, sir, we are there.
Yes, sir. Yes, sir.
I think it is rent control and subordinate jets. Yes. EV Mathai versus subordinate jets. Oh, I'm getting the sound. Here it is given the case law. I think in this case law it is decided. EV Matthias versus subordinate jets Kottayam case law. If you search it, you will know it. Where do you get the answer for this one? See, I am showing you the way how to search it also. Again, we can make it out Control F, even say 24, even it will go to that point, 24. No, it is not showing. Anyway, please check it whether it is right or wrong. Once again, the last question, that is the last question because I prepared 27th questions. The last question is a doubtful, which section actually says about that one, where the rent control is not a court under this, as it is not a subordinate to the district or high court. So now I will tell you the three-piece suit. What is meant by three-piece suit? And the next class is, what is the next period as per the schedule? As our schedule is concerned, because you read and come to the class so that let the class be the participatory class. Even one student also there, I will going to delete because it is my principle. Oh, this is the Bear Act. No, not this one. I say schedules. Schedule means timetable. But it is showing some other thing. I give the schedules to you. What is the tomorrow's?
Contract Act, sir.
Yes, Contract Act. It's for 2 days.
Yes, sir. Tomorrow and after tomorrow.
When you open the mic, I'm getting the resound. What is the reason? Are you using the direct microphone or you are using the earphone? There is something wrong. When the other people are there, when they speak, I don't get the resound. But when you speak, keep it open, I will get the resound here. What method that you are using? Are you using the earphone or are you directly using the microphone of your smartphone or laptop?
I think it is fan sound, I think, sir.
No, resound is coming. See?
Resound coming, sir.
Yeah, resound. And you could hear also in the recording also you could hear the resound. Anyway, please check it because whenever you speak, and I'm getting that. For instance, Rokia is there. When she speaks, I don't get it. Rokia, what method that you are using? Rokia, are you there? Unmute and say. I don't think that she was there. Okay, in the tomorrow class that we will going to do that. See, when you kept it open, I'm getting that sound. Srinivas, now I am not getting the sound. But when you kept it open, I am getting the sound. Means something wrong there. Either which system that you are using. Because now I am using my laptop. Directly I can speak it without using my earphone. Because in my house nobody would be there except my wife. And she will not make any sound. If anybody makes the sound, that will be recorded over here. But anyway, with this that I would like to wind up my today class. And we will meet you again the same time, 9:10 of the Indian Standard Time to 10 o'clock. And still I think there is a, now 10:08 is there now. I think Cisco WebEx is kind enough to extend it. Otherwise, sometimes it will give only 50 minutes and sometimes only 42 to 45 minutes. And today it's very kind enough to make it. If you want to ask any question, you can ask me now. Durga, are you present? Say yes. Unmute, say yes.
Sir,
Yes,
now
Sri.
it is coming.
No. There is no. No, still it is
Present,
coming.
sir.
Yeah, still it is
Sir,
coming.
is there any resound now coming?
Not now. Okay, but
Okay,
little is coming. Little is coming.
little.
Yeah, little is coming. Still there is sound. But when the other people unmute and read, I don't get the sound. But when you unmute and give the answer, I am getting the sound.
Mm-hmm.
But anyway, you check it. Why you are getting the sound?
Okay, sir. Okay.
Yeah. Because that's why I'll ask you, Srinivas, please mute it because I'm getting the sound. Even you can hear the sound in the recording also. Okay, with this, people are going away. Before they could go, I first go. End of the meeting. Jai Hind. Jai Hind.